Good afternoon, everyone. Before we get started, as some people continue to fill into the webinar, I just want to make sure everybody can see me and hear me okay. And if you can just drop a Y or a yes into the chat or raise your hand using the reaction buttons and just let me know that you can see me and you can hear me, that would be great. Awesome. Great, thank you, thank you, thank you. Just want to make sure that everything technically is working okay. All right. If you want to show your faces, you should feel free to do that. You don't need to, but feel free to do that if that would be comfortable for you. And I just want to acknowledge that we're having a little technical glitch here. You are all not named Paula Feeks. You can change your names if you need to, but for some reason, Zoom is thinking you are all Paula Feeks, but you are not. So just welcome everyone. Before we begin, I want to acknowledge you. I want you to acknowledge yourselves for being here today. I know that showing up in the middle of the day for a webinar is not always the easiest thing to do. I know that showing up in the afternoon and thinking about what happens if you are not here is also not the easiest thing to do. Because after all, who wants to spend time thinking about death? So congratulations for showing up for yourselves and more importantly, for showing up for your family. In exchange, I want to spend our time together sharing with you and teaching you much of what I've learned over the years about how to create a rock solid plan for you and for your family that will protect your family and your loved ones in a time of emergency or crisis. My name is David Feeks. I am the owner and founder of the Parents Estate Planning Law Firm in Acton. Estate planning is, and everything that we talk about today is what we do day in and day out, every day. And a lot of what I'm going to be talking about today, and a lot of what I've integrated into our practice is the result of a lot of trial and error in creating a plan for my own family. So I synthesized everything I've learned and built into my own plan. I'm going to share a lot of that here with you today. And all of our clients in the firm get the benefit of everything that I've learned along the way. I am a parent, so I have two daughters. Whether you've got young kids or whether you've got adult kids, I either am there or I have been there. I remember what it was like when my kids were little and they were with a teenage babysitter on a fairly regular basis or at daycare or preschool. And my wife, Paula, and I worrying about what would happen if something happened to both of us. And as my kids grew up, I discovered, new worries and new things to think about as we continued to update and keep our plan current to keep them protected, even as young adults. So I am where you are, or I've been where you are. And I remember along the way how I discovered all the gaps in traditional estate planning and how I filled those gaps and figured out, as I said, all the ways to keep plans updated as your family changes and your circumstances change. So I want you to stick with me all the way through to the end. I've got a lot to share with you along the way, and I've got a lot more great resources that I want to share with you at the end about how you can get more clarity that will help you to protect your family. So before we move into the meat of today's webinar, I just want to share a little light housekeeping. We're going to be together primarily for about 45 minutes. I want to leave some time for Q&A at the end. If you have questions along the way, number one, you don't have to save them until the end. Use the chat as a way for you to ask your questions. And the best way for me to know what is a question is if you just start your question with a Q and then type in your question. And then when I go back up through the chat at the end, it's easy for me to pick out questions as opposed to comments. But feel free to comment along the way too. If anything resonates with you particularly, feel free to comment, because if it resonates with you, it's very likely it is resonating with someone else as well. And today is purely educational. I am here to inform you. I'm here to educate you. I'm here to help you. But we are not, this is not legal advice I'm giving you. We are not creating an attorney-client relationship. This is purely informational and educational, and is not legal advice in any way, shape, or form. So as I said earlier, my goal for you is to walk away from our time together today with a better idea of what it takes to create that rock solid plan for your family. And not only knowing that, but knowing how to take the next steps to get started to actually creating that plan for your family. So some of you may have kids under the age of 18. Some of you may have kids over the age of 18. And I'm going to talk about both. But I want to start off by just sharing a little bit more about why I do this, and really why I get out of bed every morning and come into the office and help families day in and day out. As I mentioned earlier, my wife Paul and I are the parents of two daughters in their early 20s now. But I remember, as I said, when they were still young, and I remember Paul and I worrying about what would happen if something happened to both of us. You know, what would happen if they were at daycare and a police officer showed up? What would happen if we were out on one of our date nights and the kids were home with our babysitter and a police officer showed up on our doorstep? And when we talk about how to plan for kids who are still minors, we'll talk about the way you need to think about it. But I remember how scary it was to acknowledge that even though I was the estate planner, there were still gaps in my plan, and having to go and figure out where those gaps existed and how to fix them and fill them. And as I said, I did that, and all of our clients now get the benefit of that. We have a mission in the office, and our mission, very simply, is to not stop. Don't ever stop doing what we do until every child who needs a guardian has a guardian, starting in the Commonwealth of Massachusetts. I got to start somewhere. We start in Massachusetts. And the reason that is so important to me is, number one, I feel very strongly that every child has the right to know that their parent or parents cared enough about them to create a plan for them in case mom and dad aren't there. So that's number one. Number two is because I didn't always feel that way as a child. That when I was growing up, I didn't always feel that at least one of my parents cared enough to make sure that I was very well protected. And so that stuck with me, for better or for worse. And it's the thing that motivates me day in and day out, so that other children can know that their parents cared enough to make a plan for them to secure their future no matter what. And whether you're the parent of a young child, and that's around guardianship, or whether you're the parent of adult children, and that's just making sure that everything that you leave to them is protected to the greatest extent possible, so it can't be taken away from them by other people. Either way, it's all comes back to the exact same thing, and that's making sure your kids know that you cared enough to create a plan for them. So now let's dig in. So I want to talk really about three things, and these are all the basics of a foundational estate plan. These are the need to know, or the needs to know about a foundational estate plan. And they break down into three categories. Number one, planning for your kids. And this is particularly for those who have minor children. How to create a rock solid plan if you've got young kids. Number two is planning for your money or for your assets. And this applies to everybody, whether you've got young kids, older kids, or no kids. If you've got assets and you want to leave them to somebody, whoever that is, even if it's a charitable organization, you've got to have a plan to accomplish that. It will not accomplish itself all on its own. And number three is a plan for incapacity. And this applies to everybody who's at least 18 years of age or older. So it's for everybody on the call, and it's for everybody who has adult children. This is a really important piece for adult children. So we're going to go through them one at a time. Let's start with planning for your kids. And this is for parents with minor children. You need to create a guardianship plan for your kids if they're under the age of 18. Now, once they turn 18, they no longer need a formal legal guardian. But until they turn 18, until they become legal adults, you need someone to step in and take care of them, love them, raise them, guide them. And here's the thing, if you don't have a plan, somebody's going to decide that for you. And that someone is going to be a stranger to your family, a stranger to your kids, a stranger to you. It's going to be a probate court judge who ultimately has to make that decision. And that judge doesn't know you. That judge doesn't know what's most important to you. That judge doesn't know what's least important to you. And most importantly, that judge doesn't know who you would pick and who you would never pick. Because some of you have people in your families who you know you don't want to be the guardians of your kids. But a judge can't know that unless you tell them. And the way you tell a probate court judge exactly who you want to step in and raise your kids is by creating a plan and stating in the plan, this is who I choose. That's the process of naming guardians for your kids. Now, that's the broad picture, naming guardians for your kids. If we drill down on that a layer deep, there's two ways you want to think about guardians. There is the long term and there is the short term. And most parents have thought about the long term at some level, even if there is no plan in place. And the reason they think about it is because I'm convinced that an early warning system goes off in every parent from the moment their first child is born that basically keeps repeating itself and nagging at you. There's something you need to do to protect this child. There's something you need to do to protect this child. There's something you need to do to protect this child. The problem is a lot of parents, most parents, don't know what that protection should look like, and they don't know how to get started, which is why they push estate planning to the side. It doesn't get done, and plans don't get created, and kids go unprotected. That's how probate court judges end up making these decisions all by themselves. So you want to think about the long term, which is what happens if I die, or what happens if we die if you're married. And we'll come back to that in just a second. The other time frame, as I said, is a short-term time frame. Most parents don't think about this. Most estate planning attorneys won't help you to think about it. And the reason that they won't help you to think about it is because most traditional estate planning attorneys aren't thinking about it themselves. And that's simply because most traditional estate planning attorneys are focused on clients in their 60s and 70s and 80s who have adult children. Our firm focuses a lot of our work on families with young kids. The other side of it is our work with empty nesters, but a lot of our work is with families with young kids. And we've helped hundreds and hundreds and hundreds of young families think about all of these issues and help them to plan for all of these contingencies. And what a short-term guardian is all about is it's designed to fill the gap that exists between the moment something happens to you and the moment your long-term guardian could arrive and take over. So even if you have a plan in place and you have long-term guardians, if you don't have short-term guardians, you've got this potential gap in your plan. You've got a hole in your planning bucket. And so to fill that gap, you want to think about all of the people who live close to you, who you know and trust, who your kids know and trust, who could step in and be with your kids on a short-term basis until your long-term guardian can arrive and take over. That's the concept of short-term guardians. Because without that plan in place, what will happen if something happens to you and your kids are home with a babysitter, or they're with a daycare provider, or if they are with anyone who does not have documented legal authority to be with your kids? When the police find your children, wherever they are, knowing that something has happened to you, the police will call in the Department of Children and Family Services. And a DCF caseworker will show up at whatever location your kids are at your kids will be taken into the custody of the Massachusetts Social Service Agency. That was the piece that my wife and I, when we realized it as parents of young children, frightened us so much that I had to figure out a foolproof way to make sure that never happened. And as I said, I did figure it out. And we now build it into all of our clients' planning. And it's one of the reasons that I do webinars like this, so that I can share that concept with you, so that you can be asking the right questions and thinking about the right things and making the right decisions. And so that you don't inadvertently walk around with a planning bucket that's got a big hole in it. So that's short-term guardianship. The other side of guardianship is long-term guardians. And again, these are the people you choose to step in, care for, love, and raise your kids until they turn 18. And again, without the long-term plan in place, a judge decides all of this. So in thinking about long-term guardians, there's lots of factors to consider. Do I want to choose family? Do I want to choose friends? By the way, it doesn't have to be family. A lot of people come with a preconceived idea that they need family members to raise their kids, but they're conflicted because they know nobody in their family is the right person to raise their kids. So it doesn't have to be family. If you've got a really good friend that you know would be the best person to be the guardian for your kids, then that's the right person. Doesn't matter. Family, friends, doesn't matter. All that matters is that you choose somebody you know who could step in and raise your kids as close to the way that you would if you were still there. And then it's all about appropriately documenting your long-term guardians so a probate court judge knows what to do when the time comes. So you've given them a roadmap. You've given them instructions. This is who I want, and here's why. Now, you want to make sure you document it appropriately. You need to have at least a will to name long-term guardians, but it's not the only document you need. You need to make sure you cover the period of incapacity, as well as what happens if you die. So not only what happens if I die, what happens if I don't die? What happens if I simply can't care for my kids for a period of time? So both of those pieces, long-term and short-term, are the foundation of a good plan to protect your kids. In our office, that's actually called our kids protection plan. And every client who is the parent of minor children has that kids protection plan included in their overall plan. You can't take it out. We would never take it out. It's part of every planning level for parents with young kids. So I just want to start there. And again, any questions that pop up along the way, you can drop them into the chat. Just put a Q, a capital Q, before you post your question, and that way we can find them easily when we're going back and doing Q&A at the end. So the next thing I want to talk about is planning for your assets. What happens to your assets if something happens to you? What happens to your house? What happens to your bank accounts? What happens to your investment accounts, your retirement accounts? What happens to all of the proceeds of your life insurance policies? Now, if you don't have any plan in place, everything is going to pass without your input. In other words, you're not going to have a say in who gets those resources. Now, the people you would have wanted to get the resources may get the resources by default, because there's rules when there is no plan about who gets what. And it may turn out miraculously that the person you would have chosen had you planned is the person the default rules say get your money. Your kids are a good example. If you and your spouse die, your kids, the rules say, would be next in line to get your resources. So if you didn't have a plan in place, those assets would go to your kids. So far, so good, except the way all of it would happen would probably be what most of my clients would call disastrous. Because everything that you own at the time of your death is going to have to go through a court process. It's a court process known as probate. It is designed to identify the assets you own at the time of your death. It's designed to get accurate current values of those assets. It's designed to give your creditors a forum to make claims against those assets. And ultimately, it's designed to distribute those assets to your heirs at law, what we call your heirs at law, or the people who are entitled to receive by law your assets. Now, the probate court process has a lot of drawbacks. The first of which is it's a long process in Massachusetts. It takes at least a year, it's never faster, and can often take much longer. So your family will be dealing with probate for a year unless you plan to keep them out of probate. So it's a long process, it's an expensive process. For most people, tens of thousands of dollars go into filing fees, publishing fees, accounting and appraisal fees, legal fees, and it adds up. So it's long, it's expensive, it's cumbersome for your family. And by that, I mean your family doesn't have immediate access to your assets while they're going through probate. If they need access to those assets for any reason, to take care of your kids or for any reason at all, they need to get permission from the probate court, and that can take weeks or months depending upon where in the process things stand. If your kids are young, under the age of 18, they cannot inherit assets directly. So the court will have to appoint someone, almost always a stranger, to manage your kids' assets until they turn 18. When they turn 18, they'll be entitled to receive everything that you've left them, whether or not you think that is an appropriate age or whether or not they are financially mature enough at that age to make wise decisions about what to do with these resources. The law says when they turn 18, when they're legal adults, they're entitled to receive their inheritance. And then the last thing about probate is it's an entirely public process. So everything that gets filed with the probate court becomes a public document available for inspection by anybody who wanders into the probate court. And that is uncomfortable for a lot of people with both young children and older children, and for that matter, no children. Every probate is a public process. So with no plan, your family's going to have to go through that probate process. They may also have to pay estate taxes. The threshold for filing estate taxes in Massachusetts is $1 million. The equity value in your house counts towards that million. Bank accounts, investment accounts, retirement accounts count towards that million. And the proceeds of your life insurance policies count towards that million. So it's very easy to get over that $1 million threshold. Most of our clients are. And so that's going to trigger a potential estate tax liability. And so for some people, that's an uncomfortable reality. And then the last thing about not having a plan is that there's no way to protect the money that you leave to your kids. With a default plan in place, the money goes to your kids, as I said, at age 18. If they spend it, they spend it. If they spend it before they're 21, boom, it's gone. If they have creditor problems because they are not yet financially mature, the money is at risk from their creditors. If they ever get sued, that money is at risk. If they get married and divorced, a future divorcing spouse could claim that money as an asset subject to division in a divorce. So there's no protection around the money that you've given to them. So those are some of the problems. Now, for those of you who have a child with special needs, those problems are compounded because you have a child who may not be able to ever manage their money. And if you left the money, you may jeopardize their eligibility for government benefits. And so that is a concern as well. Now, the answer to all of these issues in terms of planning is by creating a trust. A trust is it's an estate planning tool that is an addition to a will, and in many ways takes the place of a will. A trust is something you create, manage yourself or yourselves if you're married, and you get the benefit of for as long as you're still living. And the idea is to create a trust and to transfer your existing assets into the name of the trust. Now, while you're still living, you still get to use those assets, even though it's in a trust. You still manage the trust. You have full control over the assets in the trust. You can revoke the trust or change the trust or amend the trust. So the assets remain yours while you're still living. But here's the interesting thing. The assets in a trust don't go through probate when you die. So a trust is the tool that we create for clients who don't want their families to deal with the probate court around their assets, who don't want their families to spend a full year in probate, who don't want their families to have to spend the money to get through probate, who want to give their families immediate access to their assets, who want someone they know and trust to manage that money for their kids, who want to say, this is when my kids should get my money instead of age 18, and who want to keep everything private. The trust accomplishes all of that. That is the way you get your family out of probate, is by creating a revocable trust and retitling your assets in the name of the trust. And remember, you get to still use your assets for as long as you're living, but it keeps those assets out of probate if and when you die. The other thing a trust can do, it can do two other important things that address the two other issues that I raised. Number one, it can help you to eliminate, or in some cases, minimize estate taxes to the greatest extent possible. And then the other thing it can help you to do is to protect the money that you leave to your kids, so that when they become adults, that money is used and can only be used by them, can't be taken away by anyone else, can't be taken away by a creditor, can't be taken away if they get sued, can't be taken away if they enter into a bad marriage and end up divorcing. So that is the power of a trust around your assets. It's a way to make things as easy and as seamless and as protected as possible while preserving as much of what you've left behind for the benefit of your family, as opposed to the taxing authorities or anybody working on your probate estate. And again, if you are the parent of a child with special needs, a different kind of trust is a way that you can protect the inheritance that you leave for your child in a way so that you preserve their ongoing eligibility for needs-based government benefits. So that's a really, really important piece for you all. So that is the plan around protecting your money and the plan around your assets. So the third piece I want to talk about is planning for incapacity. And this is, again, for everybody who's on the call and for any and all of you who have adult children, children who are at least 18 years of age or older. This part of the plan is appropriate for them as well. Planning for incapacity is basically saying, if I am sick, if I'm injured, and I can't make decisions for myself, I want a good plan so someone can step in and make decisions for me. Whether those decisions are in the realm of healthcare, or whether they're legal decisions, or whether they're financial decisions, or whether it's about signing a legal document for me or accessing my financial accounts, I want someone to be able to step right in and do these things for me. Now, the important thing to know if you're married is that your spouse does not automatically get to do these things for you if you're married. It does not happen automatically. You still need the plan. And when your kids turn 18, as parents, you will no longer be able to do these things for your kids. Once they are recognized as a legal adult, you can no longer make healthcare decisions for them automatically, the way you could when they were 17 and a half. You can't talk to their doctors or access their medical information the way you could when they were 17 and a half. So it's important for young adult children as well. For healthcare, here's what a good plan includes. Number one, you want a healthcare proxy. That is the legal document in Massachusetts in which you appoint someone else to make healthcare decisions for you if you can't make those decisions for yourself. You also want to have a Hipaa authorization. And that's the document that says your decision makers for healthcare can and should be able to get access to all of your medical information, all of your medical records, and they should be able to speak freely with your healthcare providers so that there is no barrier in communication, and so that your healthcare decision makers can have all of the information that they need to make reasonable, informed, and intelligent healthcare decisions on your behalf. The third document you want to have is called a living will. This is not like a last will and testament, but it is rather a roadmap that you create and leave for your healthcare decision makers that explains how you want them to make decisions around life-sustaining treatment. I want to be kept alive artificially, or I don't want to be kept alive artificially. It's a roadmap you leave so that they know how you want decisions to be made for you if you are ever in a persistent vegetative state, unconscious, terminal, and there's no expectation that you will recover a meaningful quality of life. Excuse me. The other side of incapacity planning is legal and financial decisions. And this is all done through a combined document called a durable power of attorney. Without a power of attorney, even your spouse would have to go to court and get permission to access your financial account that's in your own name, to sign legal documents on your behalf, to make legal decisions for you, to pick up your certified mail at the post office. So the way to, or manage your social media accounts. So the way to avoid having to go to court and the time and the expense that comes along with that is to name someone who can step in and do these things for you ahead of time. And again, that comes through a durable power of attorney. It is the legal document in which you designate someone to make legal, financial decisions, to sign legal documents, to basically do all of the kinds of things that you're used to doing for yourself on a day-to-day basis. But if you were incapacitated, you wouldn't be able to do those things. So again, for every adult, that is a critical part of your planning. And even for every 18-year-old and above, that is a critical part of their planning. So if you have adult children, you want to be thinking about that for them as well. And certainly when we're kind of in a back to school zone, back to college or on college breaks, we do a lot of work with existing clients and their kids to make sure that this incapacity planning gets put in place for them, so that if they get sick or if they get injured while they're at school, mom or dad can help them and do what's necessary, and they don't get shut out unnecessarily by a healthcare provider at the school who is prevented from releasing confidential information to anyone without the child's consent. These documents are a way for an adult child to give consent to their parents to help them, to be able to access information to help them. So we've covered planning for your kids. We've covered planning for your assets. We've covered planning for incapacity. Now that you know what a good plan looks like, you basically kind of know intellectually, here's what I need to do. What you don't know yet is how do you get it done? And I know that this is where people get stuck, because you can know, but as Bruce Lee said, to know and not to do is not to know. It's not enough to know, it's the doing. So I want to start you off with a question. I want you to answer this question for yourself. You don't have to say it out loud. You can say it in your head. If you want to say it out loud, that's fine too. You're all muted. No, we're not going to hear you. Here's the question. Do you want to leave things the way they are right now for your family? Do you want to leave things the way they are right now for your family? Are you okay with leaving things the way they are right now for your family? If you don't have a plan, are you okay with that? Do you want to keep that plan, that default plan, or do you want something different? Now, if you want something different, I want to give you a pathway to get this accomplished. Because you could do it yourself. You can try to do it yourself. You can try to find the resources that are out there to help you do it yourself. But do-it-yourself estate planning is a lot like do-it-yourself electrical work. When I do renovations to my house, I do not try to do the electrical work. Why not? Because I'm not an electrician. Now, could I go onto the internet and look up YouTube videos about how to do electrical wiring of your house, how to install all the wiring from the junction box to your light switches? Yes, I'm sure there are thousands of YouTube videos that would help me to understand how to do it. But I didn't go to trade school. I didn't learn how to be an electrician. I am not an electrician. And if I tried to do the wiring in my house, I would probably either electrocute myself or burn my house to the ground. Do-it-yourself estate planning is a lot like trying to wire your own house. And why would you want to burn your family's future down trying to do this yourself? I see lots of people who try to do this with somebody like LegalZoom. I'm just going to pick on LegalZoom for a moment. I could pick on anybody. Every LegalZoom plan I've ever reviewed, and I've reviewed a lot, has had 3 to 5 what I would call catastrophic mistakes. People don't know what they don't know. LegalZoom can't guide you in creating this as much as they try to convince you that they can. They really can't. And oh, by the way, I know some people who have worked as attorneys for LegalZoom who admitted that when customers called and asked questions, they gave answers without really knowing if the answer they were giving was correct. So even though LegalZoom tells you that they will help you, you really can't trust that. So as I said, every LegalZoom plan I've ever reviewed has had 3 to 5 catastrophic mistakes, which means that that plan just wasn't going to work the way the client needed it to if something happened to them, even though they thought they had everything all tied up in a neat little bow. This is a long way of saying, if you're going to get your estate planning done, hire an expert or someone who specializes in estate planning to help you. Hire somebody who does this day in and day out. Hire someone who helps families that look a lot like yours. If you're a young family with minor kids, hire somebody who does a lot of work with young families. If you're an empty nester, hire somebody who does a lot of work with empty nesters, who knows what you're going through, who knows the right questions to ask. Hire somebody who's doing this day in and day out. As I said, this is all we do at our firm. Do you want somebody doing your estate plan who is just doing it because there's not enough divorce work to do today, or not enough real estate to do today, or not enough bankruptcy, or not enough personal injury cases? Or do you want somebody who's doing this all day, every day, to the point where they've seen just about everything and they can solve just about any problem? It's your choice. Now, if you would like to hire somebody, I want to give you a pathway to make that as easy as possible. Because again, you can start scouring the internet to see if you can find the right person. Maybe you will, and maybe you won't. Here's the pathway I want to offer to you. I want to offer you time on our calendar. You guys took the time to be with us today or to listen to this recording if you weren't here with us live today. And I want to give you the opportunity of some time on our calendar. And what we do with that time is we walk you through where you are right now. We help you to get really, really clear about where you want to be instead, if where you are is not where you want to stay. We make some recommendations to you. Here's where you are. You want to be over here. Here's how you get there. Let us guide you to getting there. And then if we're a good fit for each other, we can help you to design a plan. And when we do that all in a combined meeting, it's in our initial consult. We do where you are, where do you want to be? We look at our planning levels. If it makes sense for us to work together, we use time that we've already got set aside in that first meeting to start designing your plan. So you can walk away from a planning session with us knowing you've made decisions, you've decided to get your planning in place, you've made the decisions about that planning, who's going to play what role, how you want things to work. And then you're going to come back in not so long period of time, sign your documents, and know you have a plan in place. Now you can stop thinking about it. Now you can stop worrying about it. Now you can get back to being fully present with your family instead of wondering what's going to happen to them if something happens to me. If you would like to take advantage of getting on our calendar with one of the attorneys in our office, we're going to drop into the chat a link for you to schedule a call with our intake coordinator. Her name is Lori Darling. You'll love talking to Lori. And what you can do with this link in the chat is you'll book a call with Lori. Lori will hop on the phone with you. In about 15 minutes, she'll tell you more about who we are, about our process. She'll get to know a little something about you and your family. She'll help you to evaluate whether we're a good fit for you to see if you even want to have an initial consult with us. And if you do, she can schedule you for that consult. So that first 15 minutes, there's no obligation at all. If you decide that we're not the right fit for you, if Lori determines that you may not be a good fit for us, then we'll acknowledge that right up front. Lori can even help you to find somebody who's going to be a better fit for you if it's not us. My goal is to help you get a plan. If it's with us, great. If it's with somebody else, that's okay too. I want you to have a plan. But the first step would be to book a call with Lori, hop on the phone with her for 15 minutes, and let her help you to get more clarity about everything, including whether or not we might be the right fit for you to kind of pursue planning. You'll love talking to her. Lori is awesome. Even if you just spent 15 minutes talking to her, it's still worth your 15 minutes. She's terrific. So you can use that link to book a call. We're going to drop a couple of other resources into the chat. One of them is called our Kids Protection Planning Guide. So if you're a young family with young kids, you can download our Kids Protection Planning Guide. It's free. You can use the link to grab the KPP guide, and it will give you some more details about all of the things that we've talked about today. If you're an empty nester, if you've got adult kids, we've got an empty nester guide. And so we'll drop the link right there in the chat. You can click on that, download our empty nester guide. And for you, it'll give you all the things you need to be thinking about, because it's a little bit different for empty nesters than it is for young families. So I want you to take advantage of those resources, more particularly if something about what I've been talking about today resonated with you and got you thinking, I really need to get this done, then I strongly encourage you to click the book a call link and let's schedule a call with Lori and let's see if we can figure out the next best steps for you. And hopefully that's a meeting with us where we can help you to get going on some of this planning. If you just need more general information, you can find it at our website, parentsesstateplanning.com. Again, another link in the chat, so you can just click on that. It'll take you over to our website. We've got lots of video answering frequently asked questions. We've got lots of other resources there, so feel free to head over to our website, cruise around, see what resonates with you, see what resources we have there for you. We've gathered together a lot over the years. All right, so we've got time for Q&A. I just, if you haven't dropped any question into the chat yet, just type a question in there. I'm going to hang out for a little while to see if any questions come in. I'm going to scroll back up through the chat to see if any questions have come in. It doesn't look like any have, which suggests one of two things. Either I put you all to sleep, or I did such a magnificent job explaining everything, there are no questions. But somebody always has a question. So you can feel free to ask it today if a question arises for you after today and you'd like to ask your question. A couple of ways you can do that. Number one, on our website, there's a web form. It's obvious on every page. You can just fill out the web form, post your question there. It'll get to one of our team members and we'll get back to you with an answer as quickly as we possibly can. Or you can simply send an email to info, I-N-F-O, at parentsesstateplanning.com and shoot us a question, and one of our team members will get an answer to you as well. So again, I'm going to hang out here for another minute or two. If you're thinking about your questions, if somebody is now actively typing their questions, I just want to give you a few minutes to get that in there. If not, we're done. And I thank you very much for joining us. I appreciate your time. I enjoy hopping on webinars and sharing this information. There's nothing I enjoy more than talking about estate planning. And there's nothing I enjoy more than helping people with their estate planning and getting them to think about all of the things that are important for the protection of their families, however you define family. So again, thank you all so much for joining. Seeing no questions coming through the chat, I'm going to assume that I have answered everything all along the way. But again, if anything comes up for you, info@parentsesstateplanning.com, lots of resources and information on our website, and the book a call link with Lori. If you want to take advantage of that, just quickly go ahead and click that. By the way, both the Empty Nester Guide and the Kids Protection Planning Guide are right there on the front page of our website. So if you miss it today and think of it, want to get it later, you can just go to the homepage of our website and they're front and center, so you can't miss them. All right. All right. Thank you, everybody. I really appreciate your time, and I hope to see you or talk to you somewhere down the road. Take care, everybody, and thanks for joining us. Bye-bye.